Welcome to Under the Rug at Work, where we shine light on things that are normally swept under the rug. I'm your host, Nicole Turnbull, and today I'm chatting with Dr. Skye Charry about sexual harassment. Now, this is a really big topic to unpack, so we're going to be doing a two-part series. And the first is today, where we'll focus on the legislation, and the second will be on practical guidance for workplaces. Now, I'd love to introduce you to Skye, who is an expert in sex discrimination law and the chief consultant and co-founder of SAC Consulting. She's also an author, speaker, and associate professor of law at the University of New England. Skye, thank you so much for joining me. I cannot think of anyone better to do these podcast series with me.
Oh, Nicole, it's a joy to be with you. Thank you for having me.
Now, for people who might not have met you, can you share a little bit about your background? And you've also written a book called Whispers in the Bush, which was about workplace sexual harassment in for Australian rural women. Can you share a little bit on that and what kind of made you get into the field and focus on sexual harassment in the bush?
Yes, of course. So I actually, if I take myself back in time, I left school initially at year 10, just after finishing year 10. And the reason for that was because my late mum was really unwell and she was having treatment in Sydney for breast cancer. And I was effectively at home keeping the home fires burning, so to speak. And I had a series of jobs during that phase, just to sort of, supplement income. So I was doing, my main job was as a medical receptionist, but then on the side, I was sort of, doing the belly wool in the shearing sheds, and I was fruit picking, and sometimes I was even a farmhand. And all of those experiences were really interesting when I reflected on them later on in life. So long story short, I went back to school after some time out of the workforce and went to study law at the University of Canberra. And it was really over that time that I became interested in gender and law in particular, in my studies. I practiced law in Canberra as a solicitor, moving out of university, and I was in a space that was fascinating. I was really looking at employment and discrimination matters primarily. I had my daughter Summer relatively young. So when I was on maternity leave one day, I was in the supermarket and I ran into one of my beautiful lecturers from the University of Canberra. And she asked me what I was doing. And I said to her that I'm, pushing my pram and I'm on maternity leave. And she said to me, have you considered a PhD project while you're sort of, on taking some time? And of course, I hadn't considered that at all. But she challenged me. She said to me, why don't you think about what it is that you would contribute as an original contribution if you did do a PhD? Why don't you just have a ponder? And I sat there at the kitchen table that night. I remember I'd recently watched Little Women and I'd been inspired by Jo March writing what she knew. And I pondered what I had experienced, and it was, really apparent to me that some of those experiences that happened in relative isolation were really baffling as a young person, in the bush. And I didn't necessarily have any real supports that were meaningful. And I wondered what had been understood or written about that to that point in time. And as it turned out, nothing had. And so that was effectively the way that Whispers from the Bush was born. So I travelled Australia and I went into all sorts of really interesting spaces and met with women and some men too, all around the country, and, mining and people who worked on cattle stations and beekeepers and people in forestry and police officers, you name it. And it was just such a joy to actually capture a national snapshot of experience in that space, which is what Whispers from the Bush was.
Yeah, and then that led to a documentary as well, didn't it?
It did. Oh, actually, the Victorian Women's Trust were so lovely. They actually supported me beautifully, and we put together a film called Grace Under Fire, which is available to see for free online if you'd like to. And it sort of situates, it's very short, and it situates that research journey and what we uncovered along the way.
Yes, and I will share those links in the show notes because I've watched it and it is a real eye-opener. And your background and experiences led you to where you are today, and which is why we're having this incredible chat as well, because sexual harassment is, as we said, a big topic, but also a little confusing because we have the work health and safety legislation, but the Australian Human Rights Commission also has sexual harassment and gender legislation as well. Can you share what the difference is between those two when it comes to the legislation and maybe even the enforcement?
Yeah. So I even heard someone talking on the news this morning about the sort of complexity and the confusing element around this issue. But in a sense, it can be simplified, as you know, many things can be. So sexual harassment is widely recognised now as a breach of human rights as much as it is a health and safety issue, which is why we can address sexual harassment through two complementary frameworks. So we have the work health and safety framework, which is enforced by SafeWork regulators on the one hand, and then we have anti-discrimination law enforced by the Australian Human Rights Commission on the other. So these bodies do have different roles. They're both essential, though, to creating a safe, meaningfully healthy workplace at the end of the day. Now, SafeWork operates, as we expect, under work health and safety law, and the focus is on preventing harm. So they treat health and safety as a health and safety risk in the same way that, you know, for example, in order to prevent head injuries, we wear a hard hat, for example. And on the other hand, we have the Human Rights Commission administering anti-discrimination law and focusing on rights and accountability, effectively looking at whether unlawful conduct has occurred, whether organisations are now meeting their positive duty, which I'm sure we'll talk about in a minute, which is new. So they need to be doing things that are very much proactive, as we'll discuss. But effectively, you know, then we look at, okay, so we've got these different bodies doing different things. How does the enforcement of these powers come about? Safe work regulators investigate breaches of work health and safety by issuing improvement notices, for example. They can prosecute employees for failing to manage risks. The Human Rights Commission used to rely solely on complaints being made, but now can proactively investigate in a similar way. So effectively, whilst we've got two frameworks that are quite different, they're gunning for the same thing. They're actually, you know, starting to even sort of look for that proactive proof that people are taking these issues incredibly seriously and that they're really honouring people's dignity and safety in the same breath, in the same spirit. So we have two complementary pathways. Both are slightly different in the way that they are enforced. Both are slightly different in terms of the law that's, you know, applicable, but at the end of the day, doing very similar things.
Yes. And look, you have said a few P's in there that I'd love to get your help in explaining as well. So what does it mean for organisations to have that positive duty to proactively prevent sexual harassment in the workplace?
It is a lot of P's. It's the alliteration on the P, isn't it? So what does it mean? So the positive duty is a game changer in a sense, particularly for human rights law and legislation in the way that I've just described. It means that instead of waiting for a complaint to be made, instead of waiting for someone to say, I have been subjected to unwelcome, unlawful behaviour and I don't want it to continue, it now requires all Australian organisations to be proactive rather than reactive. So we need to take reasonable and we need to take proportionate measures, that's the language of the law, to prevent, actually the language is to eliminate as far as possible sexual harassment and related harms. So we're really looking to take meaningful, proportionate measures, depending on what they might be for the organisation, to strike it out once and for all. That's the aim under the positive duty mechanism.
So following on from that, how can leaders make sure that they're meeting that duty and not just trying to tick a box?
Yeah, so there's no one size fits all approach. That's a very important piece to take away from this conversation. The law recognises that what's appropriate, for example, for a small bakery will not necessarily be what's appropriate for a large mining sort of organisation or corporation, or indeed for a cattle station, et cetera, et cetera. So the law looks at the size, the nature, and the resources of an organisation, and then we need to consider what's possible and what's reasonable according to those variables. So the key for all organisations is to engage with the guiding standards that have been provided by the Australian Human Rights Commission, and everyone can go and have a look at those on the Respect at Work website. There are 7 guiding standards, and they will really help organisations to sort of not have a checklist, but instead to actually have a guiding framework, you know, comprised of segments that show us where we need to be turning our attention. And then the real work begins, because we think, okay, so if we need to be considering, let's say, knowledge, let's say that's one of the guiding frameworks. And knowledge means that we need to make sure that everyone's aware of the workplace policy, the zero tolerance, you know, towards sexual harassment. We need to be clear about what sexual harassment is and isn't. Lots of different things need to be considered under knowledge. So therefore, how do we best disseminate that message for the workforce, for our workforce, given all of the particulars that are different? You know, for example, I do work for forestry, quite a lot of work for forestry. In that space, we don't have people sitting necessarily at their computers on a day-to-day basis. Instead, they're doing other things in the forest, in the field. They're, you know, often in trucks. They're often away from, you know, an office environment. Therefore, we need to think strategically and carefully about how we meaningfully get the key messages to people in a way that's right for them. So that's what's meant by this notion of what's reasonable and proportionate.
Yeah, and I do like the guiding principles as well. It kind of does give you, as you said, that guidance to say, well, these are the 7 areas that you need to be focusing on. But you could, as a business, be looking at it like a bit of a checklist. So one of them you've explained, and another I like to share is the leadership commitment. So you can have a look at that headline and say, right, are we meeting that? Do our leadership support this from above? Is there, you know, the policies and procedures? Do we have XYZ? So while it can feel a bit overwhelming and confusing, the guidance documents are there to help provide guidance. And this chat is there too to help make it easier to explain and understand, because it is a big topic and society's changing. And back when I was younger and before I was in the business that I'm in, I didn't really understand what sexual harassment was or meant either. I mean, I grew up in the 80s where it was okay to have, you know, posters and calendars of naked men and women in the particular, you know, workplaces. Like there's a whole bunch of things that we kind of need to be, as you said, educated with to say, well, what is and isn't appropriate. There are some really clear lines, and we often know when you get to the extremes that yes, that is definitely sexual harassment, but it's the middle bit, it's the gray area where it's like, oh gosh, what is that and what do we do? Now, you have spoken to me before about the spectrum of behaviours that can constitute sexual harassment. Can you explain these a little bit further to help?
Yes, so I think it's really important that I say at the outset that whilst there's a range of behaviours that can constitute sexual harassment, and I'll speak to some of those examples in a moment. At the outset, I'd just like to qualify that by saying that that's not to say that the behaviour that might be at the less extreme, inverted commas, sort of, you know, end of the spectrum is any less serious, because we really need to be taking all of the behaviours incredibly seriously. And there's a very good reason for that. Some of you listening might be familiar with a person whose name is Laura Bates, and she's written a whole series of amazing books, one of which is called Everyday Sexism. And in that book, she talks about sexual harassment in its early iteration as feeling like reams and reams of pinpricks, so normal that to call each one would seem facetious. And what then happens often is that, we can make allowances as a part of a culture. We can make allowances to let little things slide along the way. But what we know about sexual harassment is that if we continue to do that as a regular pattern, it's a behaviour that's known to become increasingly significant over time. And that goes back to the heart of what it's all about. It's about power. It's about little surges of power, as we'll perhaps talk about in a moment. And the law itself reflects that. So I'll say something about that in a second. But on that spectrum of harm, so to speak, there is, known to be everything from unwanted, unwelcome staring and leering at one end of the spectrum. There have been decisions made about that sort of behaviour. And you'd imagine, for example, what makes unwelcome staring and leering necessarily sexual? How is that sexual harassment? So, there can be indicators. For example, people have been known to do things like make moaning and groaning noises whilst staring at somebody in a really sort of, determined way. Or, that lascivious licking of lips, for example. There are little indicators that are very subtle that, and sometimes not so subtle, sometimes pretty overt actually and gross. But they're the things that really do have an impact on the person who's the recipient of that behaviour, because it actually makes that person feel all of a sudden rattled in terms of confidence, in terms of whether they are safe, in terms of whether they are deserving of the standard of law that we know that they are. All of a sudden, there's that power exertion changes that person's experience in the moment. And we know that in the workplace environment, we can't have room for people feeling rattled in that way, because that's a breach of psychological safety and psychosocial safety. So even without physically touching or even without saying words, we can see that at one end of the spectrum, behaviour can impact another person's well-being very badly, and for a significant period of time that goes well beyond sometimes the act itself. So that's at one end of the spectrum. And then, you're moving along the spectrum, and people can become more overt with words, with language. So unwelcome, unwanted jokes of a sexual nature. Often I see that, banter is confused. And I want to say something about this, because we really, really need to be clear about the difference between good, healthy, jovial banter that uplifts, that is team building, that's humorous, that's incredibly important as part of the Australian spirit. There's something really good about good, hard quality banter. But on the other hand, the moment that banter has the propensity, the possibility of ostracizing, of humiliating, of, sexualizing the environment at work, the moment that there are these sort of red flags, and we can call them safety flags perhaps, that pop up, we need to be really conscious about bringing that back into safer territory again for the well-being of all of the culture, and also to make sure that we're not giving tacit condonement in the way that I spoke about before to the little things that we could perhaps let slide or not. We can do that in different ways, and perhaps in our next time together, Nicole, we'll probably have a chance to talk about how we can do that without formalising, those conversations necessarily, because that's a whole conversation in itself.
It is.
And then just to sort of, finish that off for you. So we've got the thing that's not necessarily physical. We've got everything that moves into the mode of humiliating language that makes people feel like they don't belong to the team, of a sexual nature again. We've got, as you say, on that spectrum, sometimes we still see that porn appears under ute seats, in toolbox lids. We see it on shed walls. It does still pop up. And that is actually a real risk under human rights legislation, because it has the impact, well, it does actually impact people's well-being, their sense of dignity, their sense of safety in the workplace, quite often. And finally, you know, we start to move down that spectrum into a space where the physical body is also used for the sort of very selfish purposes of power exertion over another person. So unwelcome physical touching of all sorts, you know, can happen. And particularly, as you've heard me say before, I've seen this happen time and time again, where people are working in relative isolation as well, and that can actually create an incredible psychological safety risk on top of the physical experience. And you know, that's extremely bad. And we then move into a mode where we're concerned about criminality as well. So we can actually find that we slide all the way into criminal territory along that framework.
Yeah. You've shared a lot. I'm going to resist the urge to go into solutions and practical guidance, because we're going to dive into that into the next one. Because what I'd love to hear from you next is, what are some of those key legal tests to determine if a behavior qualifies as sexual harassment?
That's very important. So effectively, there are three key elements to the Commonwealth Sex Discrimination Act's definition of sexual harassment. And people can have a look at this under Section 28 of the legislation if you'd like to. To break it down, first, you know, the first element is that the behaviour must be unwelcome. So this is a subjective element. This means that whether or not something's unwelcome or not will actually be gauged by the person who is exposed to the behaviour. So that determination as to whether or not I'm experiencing something as impacting me negatively is mine to own, effectively. That's my decision, just as it is yours. And so effectively, Nicole, this allows us to really notice the nuance here, because what's unwelcome and unwanted to one person may not be unwelcome and unwanted to the next. However, as we'll go on to discover, the law says that the possibility is objectively what we need to be concerned about. So whilst the first test is effectively a heart's test, it's effectively, you know, did that land badly for the individual who experienced the behaviour? We then go on to cross-check against two further elements. So that's not the end of the story. So the first element is, you know, subjectively, was that unwelcome? This distinguishes it automatically from anything that is mutual. So if something is a mutual interaction whereby, for example, there's flirtation that's experienced as, you know, uplifting and joyful and building of relationships and a little bit delicious in some way, we know that people are effectively not experiencing a negative form of power in the way that I spoke about it before. They're actually experiencing something that's human and uplifting and lovely. Now, whilst, you know, we've also got to be conscious that along the way there might be declarations that need to be made to HR depending on the nature of the relationship. Where there is consent, where there is joy, where there is uplift, we can be sure that we're not talking about sexual harassment. So that's a nice, important distinction to be made at the outset. The second element is that the behaviour must have a sexual tone. It must be sexual in nature, which distinguishes sexual harassment from other forms of harm, including bullying, including harassment more generally. Now, you've heard me sort of speak a moment ago about how there can be all sorts of different behaviours that sit on that possible spectrum of harm, sexualised harm. Not necessarily the case, as we heard, that, you know, we need to have words involved, not necessarily the case that there needs to be physical touching involved. There are lots of different nuances in terms of what judges have decided. And so we need to be really careful and conscious about the way that we choose to engage with people, and really stop and pause and think about the third element. The third element is what's known as the possibility test. So this is where the law applies an objective standard. We are thinking about the reasonable person standing in the same circumstances and whether they would have anticipated the possibility, just the possibility, that this behaviour would create humiliation, offence, or intimidation. So effectively, this part of the test balances the individual's standard, their lived experience, and whether or not something is unwelcome to them according to all of the parts of their own heart, with that broader social standard. So the law is actually really balanced in this way, and we need all three parts of the Section 28 to be fulfilled in order for sexual harassment to be, satisfied. Yeah, it's a really important thing for people to recognise. So just to recap, the unwelcomeness lives in the hearts and minds of the person who overhears, for example, the sexualised joke in the tea room, and they perhaps don't wish to be exposed to that sexualised joke whilst they're stirring their cup of coffee on a Friday morning, thinking about what they're doing with their kids over the weekend. If, for example, that person then applies the sexual component and thinks, well, hang on, is this of a sexual nature? Yes, it is, actually. I don't want to be hearing about what these colleagues of mine have planned for the weekend. That sounds like it's too much information, and it's not what I want to be hearing about at that level on a Friday morning. And finally, we ask ourselves if, does this happen in circumstances where a reasonable person like you or I would consider that this would create offence, intimidation, or humiliation?
How should leaders and workers understand the possibility test, and why is it crucial in assessing safety risks?
So the possibility test is powerful when it's applied to sexual harassment. Basically, it's really simple. If there's a foreseeable risk of someone experiencing harm, whether it's physical or psychological in the way that we've talked about, the employer has a duty to take reasonable, proportionate steps to address it. It's as simple as that. So it's not about waiting for harm to occur. It's about creating a workplace where the risk is recognised. So, for example, there might be a known risk where you've got people who are working in a fairly sort of, let's say there's a rhythm to the work. Let's say that, for example, we have people working in an abattoir and people are on the chain, doing their work in a fairly sort of rhythmic way, and therefore one of the most important features of the culture becomes banter, because people are really engaging with one another to sort of bring some energies, to bring some positivity, to bring some teamwork, to bring some focus, to bring some laughs often. So what we've got to do then is notice that that's going to be one of the most important places where the risk lives, given the nature of the work. So therefore, it's not about waiting to see if the banter does spill into dangerous territory. It's about giving people the tools in advance to know what they're noticing, to sort of be prepared for that, and to create opportunities for meaningful conversation with people, to actually make sure that people feel as confident as they possibly can about how to do that in a way that doesn't feel overwhelming and it doesn't feel like they're jeopardizing good, healthy interpersonal relationships along the way.
Yeah. And that is directly aligned to the consultation requirement in the work health and safety legislation, right? And consultation is just checking in with your people. Hey, could this happen? Is it happening? What support tools do you need? How do you think we can eliminate it? People often know the problems they're experiencing and know the solutions as well. I always like to share too, like have a look at the statistics in the Australian Human Rights Commission and Work Health and Safety for your industry as to if sexual harassment is occurring. And again, I always say, if you've got people in your workplace, you've got the potential risk for psychosocial hazard.
Right.
People are amazing and incredible and weird and wonderful and also People. We get cranky. We have our upbringing. We bring all of our baggage with us, and
Mm,
sometimes we stick our foot in our mouth. So we need to just be aware of those things and manage them appropriately. And as you said, there are differences when it comes to banter, and uh, we need to know ourselves and know our industry. Because when it comes to, let's just say, for example, the mining industry, banter in a mining industry is very different to banter in a religious organization.
yes, it is. Yes, it
So,
is.
yeah, having that situational awareness, and it's why, as you said at the start, there's not that one size fits all. There's not those check boxes because it is so varied, so different, and the people that you're working with are the same as well. So checking in with them is and doing that prevention, doing that proactivity. Let's not wait until things happen. And guess what? We can't anymore because the legislation's changed.
Mm.
So, how should organizations approach writing policies to address sexual harassment effectively?
So a good policy will be about much, much more than just words on the page. And that's why it's important that we don't take a policy, from another organization and assume that it fits the purpose of the organization that we're actually, really wanting to write it for. It should feel real. It should feel relevant. It should really consider the variables around, who are the people who are performing the work? What is the rhythm of the work? How do people engage? How do people have access to their, supervisors or trusted leaders? Do they have access, for example, to laptops, to phones, or don't they? Is it actually tricky for people? Again, I know that in the on-plant environment, having a phone call on a mobile is really hard given the nature of the noise. Often, in different contexts that I've seen, the more remote you go, internet coverage can be hit or miss. For example, sometimes we simply need to think creatively about the mechanisms for having conversations about sexual harassment. So the policy needs to do a few things at bare minimum. It needs to really be clear about what sexual harassment is and isn't. Really needs to provide some workplace relevant examples about what that means for people.
Mm,
Then it needs to craft a spectrum of possibilities, so to speak, in terms of what you can do if you are concerned about behaviour that perhaps falls short of the standard. This ideally would incorporate some informal mechanisms for people so that if they're able to, if it's safe to do so, they can have, a more confident conversation with people about the way that perhaps a conversation has impacted, has landed for them,
yeah.
in
Yeah.
that unwelcome way.
Mm,
And ideally, we'd be, and we'll talk about this the next time I know that you and I speak, we'll be giving people tools to do that and actually tools to respond to that. And, there are some really practical things that we can upskill people with in
mm,
order to make the environment safer and in order to make the environment, conducive with people's well-being. And then on the other hand, the policy also does need to set out what happens if things don't work in that way, because sometimes they will need to be looked after. A person will need to be looked after more formally. We
mhm,
need to be clear about what those different avenues look like, how people can have conversations with others who are, tasked effectively by law with looking after their care, looking after them as people. We also need to be making sure that at the end of the day, we are having conversations with people about these words on paper in a meaningful way, that we're translating this so that it's not just, here's the policy, tick and flick. Once you've had a good look at it, pop it back to me and I'll put it in the drawer and we've done that. We can tell everyone that we've got a policy. It doesn't work that way. These are living, breathing documents that really do not need to be categorized as something that we pop in the bottom drawer and, know that it's there, but instead really need to be coming under the new legislation, the positive duty legislation, active about, having chats about, grassroots chats, even if it's allocating, for example, 15 minutes to a staff meeting, sometimes reminding people from time to time that that the door is open if people would like to talk about these things. Sometimes if people are working in shearing sheds, for example, I've seen that signage is really an important way of disseminating the message. So just as they've got signage about how you lift a sheep safely so as not to hurt your back,
Yep.
also got signage about, reminding people about what the standard is here to look after dignity, psychological safety, physical safety, all of those factors as well. So there are lots of different things to take into account.
There is, and they're great ways to consult and get your team involved. And I just say to the team and the people as well, get involved so that you can have your say and you can say, does this fit for me? Does the process make sense? And if it does happen, will I feel supported, or am I happy with the process and the steps? So Skye, thank you so much. There's so much more we're going to chat about, and so much more we could have as well. But if people want to get in touch with you and find out more and learn more, what's the best way to connect?
Well, I'm on LinkedIn, so that's really a lovely way of connecting with new people. And also, people are welcome to reach out to me on my website as well. So we have a website. Perhaps, Nicole, I can share that with you for your notes.
Yep.
And people are just very welcome to reach out and have a chat as much as they would like to, because these are important topics.
Yes.
And the more that we start to have these conversations about safety and dignity and, really humanize the conversations and take them out of the law and into the practical sort of grounded place where it should live organically, the better we're going to be, I think.
100%. 100%. And again, thank you so much for sharing the insights. I'm so looking forward to part 2, where we'll dive into the practical applications and ways that workers and workplaces can address sexual harassment. But for our listeners, if you found this conversation valuable, please subscribe and share it. We'll see you next time on Under the Rug at Work, where we continue to shine light on issues that are too often overlooked.